on record. My lords, the prayers of the first petitioner are set out in prayers A to R in the said further amended petition, which, as I have said, is dated 13th of August, 2025. The core of those prayers can be summarized as follows. One, the question, if this court agrees with our submissions, the question of the unconstitutional impeachment. Number two, payment of the remuneration he would have otherwise earned, plus, of course, all the benefits as per the law, plus damages. Finally, for the period of 2.5 years that His Excellency regarding Gachagua served as the second Deputy President of the Republic of Kenya, it is our submission that Article 151 of the Constitution is fully applicable, and I invite your Lordship and your leadership to have a look at that Article 151 when you retire. Briefly, my lord, impeachment cannot and could not have been retrospective. That is the submission. My lords, your leadership, the petitioner, first petitioner, relies on the following documents. One, his further amended petition dated 13th of August 2025, the verifying affidavit thereto, and the annexures, which are in 9 volumes, dated 18th of October 2020, of authorities and case digest, dated 7th of October, and number 3, the first petitioners written 7th October 2025, which submissions are the ones we are highlighting today before this noble court. My lords, paragraph 1 to 19 my colleague is drawing my attention that we also relying on the first petitioner's rejoinder to submissions, which you are served rather late in the day, but the rejoinder is dated 27th of April 2026. Thank you. My lords, your leadership, paragraph 1 to 19 of our written submissions sets out the critical background and gives context to the impeachment and the submissions we have made with regard to that impeachment. And I politely invite this honorable court, when it retires, to read this background in full. But permit me to briefly draw the court's attention to only 3 matters in that background. And the first one is to emphasize the total and absolute lack of meaningful public participation. And I would draw this Honorable Court's attention to paragraph 5, which you will find at page 7 of our written submissions. My Lord, page 7 of our written submission, paragraph 5, is what I'm briefly referring to. The National Assembly conducted a public participation exercise on the 4th and 5th October 2024. However, the exercise was not adequate or meaningful. The exercise did not provide the public, for example, with the side of the story. The public was only presented with the allegation made by the National Assembly. And our submission is that if there is going to be effective public participation, it was essential for the public to be presented with what the Deputy President was saying. But that was never done. In Nairobi, for example, in the county of Nairobi, the National Assembly public participation for the county of Nairobi, capital city. The public participation at the Bomas of Kenya was presided over by select ODM members of parliament from Nairobi County, who repeatedly asserted that the event was for invited guests only. Lord, it is our submission that that is a mockery of effective public participation under the contract. And you'll find what I'm saying in the exhibit, my Lord, in exhibit marked RG 5 in volume 6, page 757 to 758. And also exhibit marked RG 7 in volume 6, page 764 to 765.
For recording
Lord,
purposes,
the second issue I would like to highlight is the rush from the word
for the petition.
that the entire
His
process
Excellency
was
regarding
conducted
Gachagua
by the National Assembly
in petition
through to the Senate, breakneck speed, lightning speed.
2024,
And the question that arises
in
is
which
why
he
this
is the petitioner.
And our submission is that the only inference
And I do
that
so, my
can be
Your
drawn,
Lordship,
and we drew and we
with
invite
my
these
learned
people
friends,
to do, is that there was a
Senior
predetermined
Counsel Elisha
result
Ongoya,
that the National Assembly and the Senate
Tom
are
Macharia,
rushing to achieve. Technical
Sonia
perception
Victor
that they
Ogeto,
were doing what the Constitution
Faye
required,
Waigwa,
when in fact nothing of the sort was
John Jomo,
Present.
If you look at paragraph 8, 9, and 10, and 11,
Ochio Dudley,
and they appear from page 8 of our written submission, paragraph 8, the Lord you see,
Your
the
leadership
respondent, the third
in a
respondent,
large number of parties
convened a session of the
and
Senate
their respective
on
councils.
8th October
Therefore,
2024,
my
which
suggestion
then
is that council
passed a
adhering to the
resolution
different parties
that the plenary
introduce
would
themselves
hear
for
and
the sake of
consider.
others.
And I pause here to emphasize the word plenary, because all the constitution is having orders to the state. By impeachment proceedings into committed
My lord and my lady, I was waiting for
and
the
is the
second
person
petitioner.
to be
But it's a matter for the
any
third petitioner.
fairness
My name is
in the
Muge,
impeachment.
and I appear
The
together
Senate
with my
cannot
colleague,
legally constitution
Honorable
by
Jen-
part
Jim Jerry Minor.
that accords an opportunity to the person to be heard. What does plenary
Good morning, your lordships, your ladyship. For the fourth to the eighth petitioners, my name is Ogada. I appear with my brother Sakimpa. Thank you.
and on a collective application of the relevant provision of the
Good morning, my ladies, my lord. My name is Deb Wanjiru. I hold brief for Mr. Kibe Mungai. We appear together with Kibe Mungai for the 10th to the 41 petitioner, together with Mr. Ole Kamwaro, Mr. Nyamu, and Mr. Simon Boru. Equally well, my lady, my lord, for the 44th to 49th petitioners, the quorum remains as stated.
Your Lordship, my lady, my name is Modara Omoke, 43rd petitioner and council, and petitioner in D027 of 2024. I appear personally.
You are which petitioner?
I am the 43rd petitioner, Your Lordship.
Once more, permit me to also place my senior Mr. Maanza on the quorum for the 44th, 45th, 7th, 8th, 49th petitions.
Our the fact that somehow the National Assembly was allocated 3 hours. Yet, the person that was doing it was the Deputy President, no Lord, all these and many more is evidence of clear bias by on the part of the Senate, despite the Senate being like, I must say, by a speaker who I personally have a regard for.
I have my learned friend, Mr. Gumo, Mr. Yamodi, and Mr. Numa.
But on the second day, and I'm looking at paragraph 10, where the Deputy President was supposed to present his case, hello, he fell ill and was rushed
I have my learned
to
friend,
hospital
Dr.
for
Mokele
urgent
Polo, Senior Counsel,
rejecting the request for adjournment. The Senate voted to impeach
Ken
the Deputy
Belly.
President for 5 out of the 11 counts. And you find all that in RG 11, volume 9, pages 1689,
Ken Swan,
1725.
Boniface, Maura, and Steve.
And also RG 12, volume 9, pages 1752 1750.
Sorry, I am corrected there.
You know, the third matter, I wish to very quickly draw the court's attention to in this introduction budget.
And I am advised that there
Is
is Mr. Boyd
absolutely clear
for the first
that both the National Assembly
and that should
and
cover
the Senate
and
to address their minds to the threshold that the Constitution lays down for impeachment of a person elected into office by a plurality of votes. And here, my Lord, permit me to draw the court's attention to the fundamental distinction between presidential systems of government and parliamentary systems. In a parliamentary system of government, members of parliament are entitled and have the right to kick the prime minister out of office simply by passing a no confidence. No one can question the members of parliament why they have lost confidence.
My Lord, my name is Mike
Many
from
examples of parliamentary system in India. India, and in fact, although in South Africa they call their CEO president, it's actually a parliamentary called the president of South Africa, elected not by a plurality of votes, but by vote a majority of votes. So that distinction is important. The people of Kenya decided in August 2010 that they wanted to give unto themselves a pure presidential system. Therefore, it is not the case under our constitution that members of the National
That appears
Assembly
to complete the appearance.
and Christian, they are resolution, the ability of the Constitution, and will be addressing this fully. When in truth what they were doing was simply to say we have the numbers, passing a vote of no confidence, not violation of the Constitution. That is not what is permitted in our Constitution. And my Lord, if you look at paragraph 1 of our written submission, this is important. An impeachment is an important remedy, but one of last resort. In other words, there must be no other way of dealing with the person being impeached. One of last resort. Let me pause here to emphasize, in the National Cohesion Act, currently headed by my friend Reverend Court, one of the charges leveled against the first deputy, the first petition, was making utterances that, strictly speaking, should have been reported to the National Integration Commission. If impeachment is a last resort, why was the deputy president being rushed to impeachment on matters in respect of which he could have been taken to that National Cohesion Commission and even prosecuted? That was not respecting the important dictate in presidential system that impeachment is a last resort. It is one to be used where there is an injury to the people. Why is that? Because in a presidential system, it is the people themselves through a plurality of their votes, who elect both the president and the deputy president. The remedy should be limited to only the gravest political wrong. This is because the person to be removed from office came to that office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. And Lord, what I am highlighting here is what the court says in the song called Moving Gideon Kioko, and another was of Nairobi City Council. So this is the judicial interpretation that is being accorded in respect of presidential system. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. There should therefore be a clear nexus between the alleged wrongs with the public trust bestowed on the governor, in this case the deputy president. It is incumbent upon the High Court, and this is important, it is incumbent upon the High Court to determine if the facts in support of the charges against the deputy president meet and prove the threshold in Article 181 of the Constitution, which is why we are before this honorable court. It is, my Lord, as I say, the first time that the first petitioner has the opportunity to state his case and to point out the lack of that high standard of gross violation of the Constitution or other written law that the Constitution prescribes. My Lord, let me now, that was a few words about the introduction. Let me now go to the issues that I need to highlight. My Lord, if you go to page 11 of our written submissions, you will see 8 issues we have drafted arising from the first petitioner's petition and our written submissions as the issues we suggest that this honorable court should address in determining this issue. My Lord, those 8 issues are the ones we have divided amongst ourselves as council, appearing for the deputy president to be addressed by each one of us. My Lord, we will avoid as much as possible not to be repetitive, but there will be different dimensions to each of the issues that will be addressed by different councils. My Lord, the issues I want to address in those issues listed in paragraph 17 are 1, or rather A, whether the motion at the National Assembly met the constitutional threshold under Article 145 and whether there was adequate public participation. And the second one is C, whether the Senate, misled by its interpretation of Article 145, rushed the process and denied the Deputy President a fair hearing. And it is our submission, very critical submission, as we shall be seeking to do here, that the Deputy President was denied a fair hearing. And a fair hearing is cardinal in our administration of justice from time immemorial, even prior to the 2020 Constitution. And the third one is whether the overnight clearances for the replacement Deputy President evidenced a predetermined process compounded by the violations. Whether that was unconstitutional. My Lord, your leadership, the motion by the National Assembly was defective and failed to meet the constitutional threshold. First, the allegations and evidence in the impeachment motion at the National Assembly simply did not meet the constitutional threshold of Article 145(1). And you will find that in Exhibit RG1, Volume 1, page 2 to 41, which is the motion. My Lord, in Martin, Nyaga, Wambora, and 3 others, the Court of Appeal held that the facts that prove gross violation must be proved before the relevant constitutional court. My Lord, your leadership, my learned friend Gachagua here, and myself had the privilege of arguing the Wabora case. It is a high standard in presidential systems. Not each, and you'll find that in the Wambora case, our Battle of Authorities, paragraph 45, pages 45 to 46. Not each violation of the Constitution amounts to gross violation. No, the drafters of the Constitution could have said violation of the Constitution or other reason. No, they didn't. The word gross must carry the true intention of the drafters of our Constitution. This is the Court of Appeal in the Wabora case saying not every violation amounts to a gross violation. The charge must expressly state that the alleged violation is gross and give particulars of the alleged gross violation. Whatever is alleged against the governor, in this case deputy governor, may I say, not just the deputy governor, the law that this court will be laid down or reiterate will apply to the impeachment of the president himself. It's a very weighty issue that this court is asked to confront. Whatever is alleged must be serious, substantial, and weight. There must be a nexus between the person to be impeached and the alleged gross violation of the Constitution or any other written law. The charges framed against the governor or deputy president of the country and the particulars thereof must disclose a gross violation of the Constitution or any other written law. D, the charges as framed must state with a degree of precision the article or articles, even sub-articles of the Constitution or the provisions of any other written law that have been allegedly been grossly violated. Here, my lords, in the case before this honorable court, the allegations were vague, lacking in detail, and wholly unfounded. Besides, the National Assembly erred in failing to apply the threshold and standard of proof applicable to impeachment proceedings, thus violating Article 145. For example, although the court in the Robert Alive as an Attorney General case, which is reported in 2017, 6090, nullified Section 132 of the Penal Code. The court nullified Section 132 of the Penal Code. 5 years before the Deputy President's election to office, ground 8 of the impeachment motion alleged that the Deputy President had violated that nullified law warranting his removal from office by impeaching the Deputy President on the basis of a section that had been nullified by this court. What he didn't know was the National Assembly sending to the public who had elected the Deputy President with over 71 million votes. This is demonstrative of the casualness of the National Assembly in performing a very important duty imposed by the Constitution of impeachment. My Lord, you find that authority, paragraph 62, allied case, pages 62 to 63. And although Article 145(1)(b) only applies where there are serious reasons for believing that the Deputy President has committed a crime, in ground 8, the National Assembly resolved to impeach the Deputy President for, among others, violations of a nullified law. The National Assembly then informed the Speaker of the Senate of that resolution, finding that the